Harold, I was going to take you to the Munich case.
Munich, yes.
Which is at Article 5 of the authority, 88. My lord, the case concerned the interpretation of the reinsurance policy, and the issue was the correlation, if you like, between the terms of the insurance policy and the reinsurance policy. And essentially, you see from paragraph 1 of the judgment, it was Ascot who reinsured Munich Re in respect of Munich's liability under the underlying insurance policy. And the underlying insurance policy provided cover for a project period and then for a lower level of cover for a maintenance period. And the project period was to run for a fixed period of time. The maintenance period was then to run for a 12-month period after the expiry of the project period. And you can see that in paragraph 15.
Sorry, which paragraph?
15.
15.
And you see the project period and the maintenance period. It's the wording of the maintenance period that's particularly crucial. The reinsurance policy, which is governed by English law, incorporated all the terms of the underlying policy. And if you look at paragraph 2, the last sentence, you can see that it was common ground that it was intended to be back-to-back with the insurance policy. But when the project overran, Munich Re agreed to extend the project period under the underlying insurance policy, but in error failed to correspondingly extend the terms of the reinsurance policy. You can see that in paragraph 3. And the competing arguments were essentially that Munich Re said, even though it had failed to extend the project period under the reinsurance policy which had expired, it benefited from the maintenance period, reading the clause literally. And Ascot argued that despite the literal interpretation, the maintenance period had not begun upon the expiry of the project period as it said, because it had been intended by the parties that it would only cover the maintenance after the end of the construction period, which had happened. And the relevant clause, you can see set out at paragraph 30. The question was, when did the maintenance period begin? Given the literal wording, but given the background to the contract. And at paragraph 50, the judge held, understandably, that the maintenance period read literally supported Munich's argument, but that she was not persuaded, nevertheless, that the construction was right. And the judge, if one goes back to paragraph 43, the heading the law, reached her conclusion based upon case law that she set out, Arnold and Britton and Chartbrook. And obviously at paragraph 18 she puts this well-known proposition that the worse the drafting, the more ready the court can be properly to depart from the natural meaning. And 19, she refers to 19 as the citation instances.
Sorry, 19 is in the quotation from.
It appears to be
In the quotation
from
from Arnold and Britton. Is it?
It is.
Yeah.
19, she makes the point that commercial common sense is not to be invoked retrospectively.
Yeah. I think that's Lord Newberg that's pointed
That's
that.
right. Lord Newey, the judge relies on it.
Yes.
I just highlight that because that's not what I'm doing. It's, if one drops down, commercial common sense is only relevant to the extent of how matters could have been perceived by the parties or reasonable position in the parties' place as at the date of the contract. Now that's the territory I am in, and I'll show you why. And then Mrs. Justice Carr, as she then was, cites at 45 a conclusion from what the court is to identify. And then in the middle of the paragraph, the meaning has to be assessed in light of the natural and ordinary meaning of the clause, any other relevant provision of the contract, the overall purpose of the clause and the contract, the facts and circumstances known or assumed by the parties at the time the document was executed, and commercial common sense.
Yeah.
And then at paragraph 48 onwards, she says, given the issues arising on the facts of this case, it's helpful to refer to two further authorities, specifically dealing with the exercise of contractual interpretation in changed factual circumstances against the background of Britain. Here she cites the Gromer case and also the Naval case.
Yeah.
And that leads her to the conclusion that the literal reading, despite it being clear on its face, isn't right, because, as she says at paragraph 51, clause 21 calls to be construed circumstances not objectively envisaged at the time the parties entered into the insurance policy, and she relies on what was objectively contemplated. And if one also looks at paragraph 53 and to 55. The judge then went on in paragraph 56 to look at the context, the commercial context, which she regarded as important. And if I would just refer to paragraph 57 and 66.
So we'll see what she's actually doing. So we've got project period. That's in paragraph 15, I think, is it?
That's right.
The relevant definition.
That's right.
So it attaches on the 1st of March 2011. Covers until 30th March 2014, but not beyond 30th September 2014. And she says at 67, it did not expire on the 30th of September 2014.
That's right, because an extension was given under the insurance policy, which was then not mirrored in the reinsurance policy. So the point was that under the insurance policy, the project period carried on, but under the reinsurance policy, it had expired, and therefore the maintenance period kicked in under the reinsurance policy, even though that didn't mirror what was happening with the insurance policy.
So in practical terms, she has excised the words not beyond 30th September.
And she did that, you can see, based on, for example, paragraph 51, on the objective understanding that the insurance policy was mirroring the reinsurance policy, and essentially that they were part of a contractual or wider contractual structure, rather than literally construing the words in the reinsurance policy.
Does that go a bit further than the previous cases? I mean, Lord Justice Sedley, in the bit that's quoted in the book, says you've got to be creative with the words.
That's right.
Well, that's not being creative with the words, that's striking out the words.
But I think in a sense that's what he's envisaging, because the premise is that the words don't say what the court is going to do, and that's why you get into the theoretical objective intention, because you're describing the intention the parties never really had. But the reason this case is significant is not just because it goes beyond. It shows in a back-to-back commercial contractual situation where you can glean an understanding from contract A what was supposed to happen with contract B. You should look at it as part of the picture, having in mind the commercial consequences. And here, the commercial consequences were that it would be nonsensical to have the period kicking in of the maintenance when the project was still on foot. Now, in our situation, as we know, it's nonsensical to have a never-ending loop, and there is a back-to-back contract one should have a look at to see which out of the two was envisaged to be seen.
Whose intention are we looking at? For the purpose of this argument.
The parties to the sub-notes. And I shall come on to show you the parties to the sub-notes were well aware of the dividend stopper and the terms of the limited partnership agreements. And that's why you can ascribe intention to them. And I'll also come on to why the fact that their notes isn't relevant in this case. So shall I move on then to show you actually what I rely on? The starting point is the ECAPs, and the ECAPs are the holders of the sub-notes, of which GP1 is the general partner. And the background to this one is that PLC, part of the Lehman structure, wanted to raise money from external investors for tax and regulatory reasons to reduce the internal debt. And there were different benefits think that's common ground. LBHI set up the 3 partnerships with GP1 as the general partner, as Tim has explained. Partnerships then issued the ECAPs to the external investors, and partnerships then used the money raised to buy the subnotes from PLC. So there's a back-to-back structure, the purpose of which is to get some external funding in and hold monies in a way that gives tax benefits. The subnotes were only ever intended to be issued by PLC to the partnerships, so they're all Lehman entities. So although these are notes listed on Channel Islands Stock Exchange, they were listed for tax purposes, and for all real purposes, they are an internal structure used to fund tradable securities in the ECAPs. So the PLC notes are an internal, essentially, Lehman's construct.
When you say they were listed for tax purposes, is there evidence or a finding to support that?
Well, I'll show you the terms of it, because what you can see from the terms of the notes is that they had to be tradable, but then immediately, if they were traded, they were immediately replaced on the same terms. And that we deduce is for tax reasons. So the idea was to provide a funding mechanism. And because they're only ever intended to be held within the Lehman's group, we say that for these purposes, your lordship can not regard them as third-party negotiable instruments for the purposes of looking at contracts. And that's why we say that you can construe it as well or imply a term, whereas I understand that usually in tradable notes one would be quite reluctant to do that.
If the terms contemplated that they might be sold to third parties, albeit they would then have to be replaced with something similar.
Exactly.
Well, isn't this rather against you? Because that does contemplate them going outside the Lehman Group.
I would say that, but I would also say that was a construct as much as itself, because they had to be contemplated to be tradable to get the tax benefits, is my submission. There's no evidence they were traded, and if they were traded, they would then immediately have to be replaced on the same terms.
But isn't the point that the notes would then, in that situation, they would go outside the Lehman Group, and that therefore must, one might think, inform the approach to the construction?
I fully accept.
I mean, you're not suggesting that this is a sham.
I'm not suggesting it's a sham, but I'm suggesting that because of the reasoning behind setting them up, and when looking at the terms being something that one can't construe easily, one can see that first of all they weren't in fact ever traded out of the group. The purpose of them was not for them to be traded out of the group. Absolutely accept that the terms suggest it was possible for them to do so, but the fact that they then had to be replaced on immediate terms, identical terms, supports my case that this was a structure put in place for tax and regulatory reasons, and therefore the relevant knowledge and or intentions, like Lord Justice Lewison said, is of the party holders to the notes, and the prospect of bringing in third parties' knowledge, we submit, is actually less relevant on the facts of this case. If you're against me on that,
I must say I share my Lord's scepticism. First of all, because as he rightly says, they were tradable notes. Secondly, because the intention of the Lehman entities not to trade them outside the group sounds suspiciously like subjective intention. So
I wasn't taking that as subjective, I was taking it as objective, because the structure of this construct was only to fund the ECAPs. So there would have been no purpose in trading them out of the group. So I'm not relying on the subjective intention, I'm relying on the objective structure looked at as a whole. And in any case, even if you were looking at it from the perspective of them being traded out, it wouldn't make any sense in the interests of note holders who might acquire the notes to construe the sub-notes as junior. So even if you did take into account the intentions of a possible third party, looking at this structure with the dividend stopper, we would submit, which would be relevant to anybody buying the notes, they would assume, we would suggest, that they wouldn't be inferior to internal women debt.
So what, the dividend stopper agreement, or the agreement which contains the dividend stopper, would pass to a third-party buyer of the notes, are you saying?
I think they could have been aware of it because the third party would see it in the ECAP's offering circular. So can I show you the documents?
But, well, maybe I haven't understood the structure, but the notes are separate from the ECAPs.
They are, but they are part of the back-to-back structure.
Yes, but we're thinking about what happens if the notes are traded. The ECAPs could stay where they are.
That's right. But the holders of the subnotes being used to fund the ECAPs would probably be aware, we would suggest, because of the back-to-back structure. A bit like the reinsurance policy and the insurance policy.
Anyway, you wanted to show us something.
Yes, please. Core bundle 3 at tab 50. I think it's Hilliard showed you this is more.
Tab 50.
Tab 50. This is the ECAP's offering circular. And if one starts with the investment considerations, and over the page you see the reference to distribution.
Sorry, where are we?
I was just showing you
Page-
heading investment considerations.
Yeah, page 889.
889.
Yeah.
And then over the page within that section is distribution of capital stopper.
Yeah.
And that's page 890. Then if you then go over the page to 891, you see the issuer is LBUK Capital Funding LP. And you see at the bottom of the bullet points that the issuer's principal asset will be the subordinated notes, the PLC notes. And at the bottom of that page, you see the use of the proceeds. You can see the structure of this being the funding for the subnotes. On page 892, you see the distribution rate definition. And if you could read the first two paragraphs. And then drop down to the paragraph that starts, the holders will be entitled to receive distributions only if the issuer, if your lordship could read over the next page. So from this you can see that distributions were payable annually, but only if the issuer has received sufficient funds under the PLC subnotes, and as long as GP1 has not published a no payment notice. And then if you go to bundle 4 at 53, keep open bundle 3, please. Tab 50. This is part of one of the partnership agreements. And if you go to 1168 of the bundle, And you also see in this agreement at page,
What are we actually looking at here?
I was looking at page.
Yeah, this is a schedule which does what?
Page 1168.
Yeah.
And this was showing you the underlying terms in the partnership agreement I've just shown you in the offering circuit. Terms of securities.
I'm sorry, I'm not quite there. 1162.
1168.
Yeah, 1162 starts schedule to terms of
Yes.
preferred securities. And that's the part of the document we're looking at.
That's right, and that is the attachment to the limited partnership agreement.
And the preferred securities are the ECAPs.
And so this is just showing you the underlying terms annexed to the partnership agreement, which also contains at 1155 the dividend stopper by way of an undertaking of the DHI. 1155.
55.
Going back to the offering circular, which was in bundle 3 that we were just looking at, you also see that advertised, that distribution of capital stopper at page 893. And then I should show you at 895 the eligible investment rate. Which, as I've accepted, shows that these could be traded, but has the clause that they will be substituted on identical terms. And the limited partnership agreement containing the dividend stopper was available for inspection to anybody buying.
Sorry, could you say that again?
The limited partnership agreement was available for inspection for anybody buying the subjects.
Thank you.
That's how they would have known about the dividend stopper. And the upshot of this structure was that LBHI had to ensure that regular payments were made under the ECAP, or else it would be forced to suspend its whole dividend and stock repurchase programme for a full year until after the regular distributions were due. And if one looks at the judgment at paragraph 366, the judge recorded a number of these points in the findings that are challenged by both sides.
Just a moment.
Page 462 in the bundle.
Yes.
And he records that only if the issuer has received sufficient funds under the PLC sub-notes. He records the no payment notice, and he records that it was that discretionary nature of the obligation to pay distributions which enabled the tax benefits.
Yeah.
He then records the partnerships constituted by limited partnership agreements to which LBHI was a party, and he records that in subparagraph 5, the damaging consequences if the dividend stopper had been triggered. Then over the page, he's finding that one can imagine the lengths that LBHI would go to avoid triggering the dividend stopper, and that this would act as a kind of commercial assurance to the ECAS holders that the distributions would in fact be made. But if it wasn't there, the distributions come from the subnotes. And if you drop down to the end of subparagraph 6, the whole point of the dividend stopper, as I see it, is to create a commercial incentive on LBHI to ensure that PLC could pay. Now the judge, just while I'm in the judgment, the judge then drops down at 368. I'm going to come back to the judge's approach. But obviously he criticises the arguments on the basis they bear no reference to the terms of the instruments themselves, and says he will consider them. In fact, he doesn't then go on to consider the bank's argument, but rather considers the impact of the evidence he heard, a different argument, and I'll show you that in a moment.
Well, there are two ways you might put this argument. One is to use it in support of Ms. Hilliard's construction. But at the beginning of this section of your submissions, you asked us to assume that she was wrong about that, and that there was a circularity between claims C and D. So are you disavowing reliance on the dividend stopper argument as an additional prop for Ms. Hilliard's argument, or not?
Ms. Hilliard's argument relies just purely on the terms
Yes.
themselves not having a circularity.
Yes.
To the extent she needs a commercial reason for her construction, and obviously the dividend stopper would assist, but the way she has argued it is that she doesn't.
No, I understand that.
And so the answer is that the argument, as is in its primary form, arises if there's a circularity, one needs to look at what the party would have intended. I think your Lordship's point is the party's actual intention could also be relied on as informing the construction.
Yes, I mean, does it enable us to, or does it help us to choose between the rival interpretations, or does it come into play after we have considered interpretation and come to the conclusion that there is a circularity? That's really my question.
And I think,
or is it both?
I think it could be both, my lord, and perhaps whichever one would win.
Well, yes, so that's, if I may say so, a typical advocate's response.
I think the answer, my lord, is that, strictly speaking, if your Lordship can see a commercial intention that informs the actual words used, and you accept Ms. Hilliard's construction with the different definitions, then yes, of course, this would inform that argument. It also, however, informs a separate argument, which is if you consider that the words used simply don't give a solution, and you have to look for something else.
Yeah.
And what we say is, and this isn't just a commercial argument, this is what the parties must have more than that. Because it's in a back-to-back structure, which I'm not sure the judge gave any credence to. But once you understand that the only way the PLC notes could pay the ECAP's dividends, and that the non-payment of the ECAP's distributions, so-called, would be catastrophic, you would understand why you would prioritise the payment of the notes over what was about 25 billion of internal debt, if it came to it. Because why would you keep it competing? And that may give a clue to why the wording is what it is. So you're right, that could give the actual intention. Or if the wording's nonsensical, that would be the sensible choice to make, as indeed Mrs. Justice Carr, in the case I showed you did. Because it doesn't make sense. First of all, we know it can't be pari passu. It is the truth looking at the wording and the very fact there's a contractual agreement. The only way the judge got to pari passu, and I'll show you this, is through two mechanisms. He got to it, one, because he approached it from an entirely wrong perspective, and I'll show you. He looked at the tranches of the sub-debt and then applied the same reasoning, and the two don't go across. I'll show you that. But secondly, and more colloquially, he got to it by just saying the contract is hopeless. And your Lordship may conclude the contract is hopeless, but it would have to have been having gone through the exercise of saying the contract's hopeless and we can't ascertain from the words and or the objective circumstances what the parties would have intended, so we essentially abandon the contract. And that's what the judge didn't do. He treated it as if it was another option, but it really wasn't another option, it was the contract doesn't work. So, my Lord, can I just show you what the judge actually did?
Yes.
And why he got to his conclusion and why it's wrong. So the relevant section of the judgment is paragraphs 151 to 154. And what the judge is dealing with here are the sub-tranches of the same debt.
Yes.
So it's claim A, little 1, little 2, little 3, all of which were in materially the same terms. And what the judge did was to essentially say, at paragraph 152, that it was all circular because they were all in the same terms, and therefore he couldn't break the circle. And what he then does in paragraph 155 onwards is essentially conclude, and the conclusion is at paragraph 250, page 41, that it's all meaningless.
Yes.
And he says it's because in 249 that you can't work through an interpretive approach. Now, in relation to the tranches of the sub-debt, the three tranches, there was no need to go down that route. Because if you go back to the definition of subordinated liabilities, and this is in the LBHI2 agreement, and it's at bundle 3, tab 38. Page 676. So you've got here the individual tranches of the same sub-debt, 1, the words all liabilities to the lender in respect of the loan, etc. Now, the word lender causes no difficulty when you read it across the three tranches of the same debt. It's the same lender. And it would be true of any future lender because it includes any committed lender. The word agreement is not separately defined, but looking at the ordinary meaning of the words, you could happily construe agreement as including the same three tranches under the same debt. It's not a stretch to say each tranche of one debt is covered by this agreement. There is a contractual interpretation. Because you wouldn't be construing the word agreement when you're looking at three tranches of the same debt in a vacuum. You know that the other two tranches exist. Or could exist.
Well, you do now, but you construe it at the date of the agreement.
But you know it could exist if they were going to, they could have had future tranches.
Future tranches. Would they not be different debts?
There'd be different debts, but under the same agreement between the same party. And that's the crucial point. If the judge had looked at, it was a permissible construction as a matter of commercial common sense to say, for the purposes of this, it's not circular, because this agreement can be read wider to encompass the other tranches of the same subdebt between the same parties on materially identical terms issued for the same purpose. And therefore, it was possible to reach a conclusion that they ranked pari passu, other than simply saying none of it works, I'm going to set it all aside. He could have at least engaged in that process. He didn't. What he did was simply say, because they're all the same, and it's the same tranches, it doesn't work, therefore it's pari passu. And he then moved over the same reason it doesn't work to claim C and D. And what we say is that was wrong because there was a commercial construction, whether it's Bromer-in or actual words, that we could have made that work in a sensible way. The same isn't true, just to take the point out of the play, isn't true as between the subdebt and the subnote because of its different parties. And so the same analysis doesn't work in relation to C and D. And so we suggest that, first of all, the judge just didn't engage in even the process. Your Lordship may not agree that that's the right answer, but it was obviously commercially sensible that you looked at the three different tranches of the same debt and saw whether the agreement properly read could be construed to mean all of them. Yeah. And he didn't do that. He just simply, in a sense, put up his hand and said, it doesn't work, it's meaningless. And because this is meaningless, everything else is meaningless, so it's all pari passu. So, and Ms. Hilliard's already addressed you on why we say that reaching pari passu as between the notes and debt, C and D, it is wrong because actually the express terms, if they do anything, indicate that pari passu wasn't what the parties intended. And at least the judge should have engaged with that.
Yes.
I was coming back to then the dividend stock. Your Lordship's heard my argument as to why we say it's relevant and how it comes into play. I fully accept that one might say, well, I understand the dividend stock, I understand all the commercial consequences, but why does it affect the ranking in the subnote subdebt? So that's the question. And the answer to that on my case is that, first of all, it's not two unconnected contracts. They are back-to-back structure, so it's obvious that you would look at it all in the round together. Once you approach it, and everybody would have known about that, I've shown you the documentation, that's how it was put together. Once you approach it from the perspective of the back-to-back structure, having regard to that really quite strikingly unusual commercial incentive and the structure of it being to ensure that the notes would be paying through to the ECAPs, you do understand that, if nothing else, the parties wanted to make sure that the notes paid the ECAPs. That must be right. That leaves you then with the third step, which is that if you've got a situation, which I suggest we do, where the notes and the debt have to be either junior or senior, due to the parties' express agreement so far as it goes, then it's obvious that had the parties addressed their minds to it, and given that commercial undertaking in place, they would have wanted to ensure that the notes took priority of the debt, and they're both subordinated, no one shied away from that, but the notes would take priority over the debt, because any other conclusion would be irrational, and one has to look at it when they were solvent.
But if the borrower was solvent, why would it matter?
Because the dividend stopper was so crucial that, let's say, for any reason, payment couldn't be made under the notes and debt. They wouldn't have wanted to trigger having to pay the debt at the same time as the notes on a cash flow basis or any other basis.
Well, one would have thought if they couldn't pay the distributions, they weren't solvent.
But it's not just the solvency test requires them to pay everything. So they could have had, so this, I'm coming on to this meets my own friend's point over the timing. They needed to be able to pay everything. So they could have been solvent on a cash flow basis, but not on the solvency test basis, which was what the trigger was here.
Oh, the ordinary cash flow or balance sheet.
Yeah. Exactly. So that's why we say that when you look at that, it isn't Deutsche Bank simply saying, here's a commercial reason, therefore you must construe. There is actually an absolute link in the structure, and it's put together on that basis. And nobody's saying that the parties discuss this or form this view, and that's what the terms say. What's being said here is the parties, this is on the premise that the parties didn't discuss it, but you can draw their intention from the back-to-back contract. And I would say, my lord, putting aside the question over does it help Ms. Hilliard's argument, in this scenario, you've got the judge's approach, Mr. Phillips's approach, and my approach, all of which require you, in a sense, to try and impose a solution. I'm going to come on to Mr. Phillips's approach because he's saying that his approach is either a purposive construction or an implied term, or very passive. The judge is saying there's no contract. So all three approaches recognise there's a problem that has to be resolved, and Deutsche Bank's approach is the only one that says, well, here's the contractual structure, and you can see how it was set up, and there's a good commercial reason why, if you had to pick between the sub-notes and the sub-debt, the notes would rank senior. And that was actually in LBHI's own interests, as the judge recognised.
Yeah.
Right, can I then address the criticisms of my argument made by Mr. Phillips? And they are at paragraph 61 of his skeleton argument in tab 19 of core bundle 1.
Sorry, could you repeat the paragraph?
It's paragraph 61.
Thank you.
It's at page 308. Union that I said 25 billion could be sub-debt, and back to my maths is wrong, it's around 50 billion. So at paragraph 61, 1 to 2, my own friend suggests that the bank is wrong because the judge accepted LBHA's case, denying that the commercial incentive identified by the judge required any particular priority. We submit, irrespective of the fact that we criticise the judge's judgment anyway, we don't think we reach that conclusion. And what he said, as Mr. Phillips sets out in paragraph 2 of his skeleton 61.2, the judge concluded that the overriding purpose of the subordinated debt structure was to provide regulatory capital. That's in his judgment of paragraph 15. He concluded that the structure of the ECAPs, including the dividend stocker, was driven by tax efficiency. That's at 373 subparagraph 2 of his judgment. But what we say is that that only explains why there was a dividend stopper in the first place. It doesn't say anything about then commercial incentives created by the dividend stopper. And one of the reasons that Your Lordships need to treat the judge's judgment on the conclusions he draws about the dividend stopper with some caution is that, and it's probably a good time to show you, I showed you how he accepted the bank's case as to the dividend stopper and how it came about and its purpose. What then happened was he deals with, in section 369 of his judgment, that's at page 464.
464.
He deals with the evidence, and I'm not suggesting that Your Lordship has to read the whole of this, but if one just goes through the pages to 467,
Yeah, he didn't think much of Mr. Katz, though.
he really didn't. His evidence was very roundly rejected. I don't shy away from that. But what you can see is in subparagraph 2 of 373 is that what the judge didn't believe was the suggestion Mr. Katz made in his oral evidence for the first time that there had been an actual discussion about the ranking. And you can see that in subparagraph 2 and 3. And subparagraph 4 as well. He insisted that there had been discussions.
Yes.
What I can show you, but I won't turn it up unless Your Lordship wishes to see it, is that in the written opening submissions of the bank and the written closing submissions of the bank, the case that was put by the bank is the one I'm putting to Your Lordship. It's an objective exercise on the basis that there had been no agreement as to it. But the judge didn't deal with that case, and it was very clearly set out in the closing that it was not a case supporting the suggestion of actual intention. But what the judge deals with in his judgment is the actual intention case. And you see that in the conclusion paragraph at 376. The dividend stopper argument played upon its facts. And he says that the evidence would go to contradicting or varying the meaning. It's not actually clear what clear meaning the judge has attached to it, but and then he says the factual matrix needs to be treated with some caution. That was his general comment. And then thirdly, he talks about material relating to the drafting history of documents. So what he's dealing with in here is a case that there was an actual discussion, even though it wasn't recorded in the documentary evidence, he rejects that case. He doesn't deal with the case that I'm putting to you, that this is an
Well, you're saying doesn't matter what Mr. Katz said, just look at the document.
And indeed, he said that on his and so the reason why this is relevant is that my learned friend tries to suggest the judge made certain findings about the nature of the dividend stopper, but the paragraph he was citing as relying on is 373 subparagraph 2. And in this paragraph, what the judge is doing is explaining why he disbelieves Katz's evidence. He's not making a finding that the dividend stopper had no consequences beyond tax consequences. And indeed, we've seen that he, in fact, makes the opposite finding. Going back to paragraph 63 of my learned friend's skeleton, I don't know if your lordship still has that open. That's in bundle 1 at tab 19.
Yeah, 63, yeah.
His next criticism is that the bank relies on a false factual premise that the incentive on LBHI requires claim C to be payable in priority to B. And he makes 2 points. At paragraph 64, he said it's wrong that the notes and the debt we're wrong that we say that they were competing because payments were due on different dates. This is the point that I just alluded to. That point's wrong because it misunderstands how the solvency condition operates in the PLC subnotes. And your lordship will remember we looked at it. It's clause 3A of the subnotes. And it requires the solvency test looks at the ability to pay liabilities in full. It is not a cash flow test. So the issue isn't that there's insufficient cash to make any one computable, two computable payment at any one time. The issue is at a time when a payment under the notes would otherwise fall due, PLC is contractually precluded from making that payment unless it can satisfy the contractual solvency test. And that looks at total assets and liabilities. And so the actual management of payments is irrelevant. The judge had it was irrelevant at trial, and that's why that's not a good point. The second point that's made is at paragraph 65 that there'd be no competition if the PLC sub-debt were a subordinated liability under the sub-notes, because they'd be excluded by the solvency test. And there are 2 answers to that. The first is that even if it was possible for claim C to be a subordinated liability under the notes, notwithstanding the apparent circularity of the terms, the same isn't true the other way round. That's Ms. Hillard's point. There's a difference in the definition. And the second point is that the function of the solvency test in these instruments, as I've said, is that no sums are payable unless and until the test is satisfied. And so if the notes and the debt are subordinated liabilities and rank pari passu, then PLC is contractually obliged to make payments under each instrument without taking into account its ability to pay under the other. If, on the other hand, the subnotes are a senior liability under the subdebt, then in a liquidity-constrained scenario, nothing would be payable under the subdebt unless and until there were sufficient assets to pay the subnotes. And that's why there's a competition point. And then finally, at 71, Mr. Phillips suggests there's a linguistic inconsistency. But I think that's true of all of us. We're all saying that the express terms require some help. So can I come on then to the problems with Mr. Phillips' case, by contrast to what he says are the problems with mine? And we can see his case at 81 of the same document. Paragraph 8. is being said by LBHI is that you can construe the agreements commercially or purposively in order to find that it operates on a pari passu basis. Alternatively, that there's an implied term, although it's not very clear what the implied term would be. And the key difference we would say is that we can't discern a purposive construction within the arguments that are put forward. The reasons that are given are twofold. First of all, it's said, paragraph 80, that the subordination categories in the PLC subdebt and subnotes are entirely symmetrical. Now that's not right, because we've seen that the definitions are in fact different and there's no engagement with that. But it's in any case uncertain why the similarity of the definitions would give a pari passu ranking, because as far as we can see, they're operating to make each other senior or junior. And on this hypothesis, all the provisions do is create a circularity, and it's not therefore clear why that would lead to pari passu by way of a purposive construction. The second reason, which I think is the main reason Craven aid, is that the regulatory regime and statutory default favours a pari passu ranking. And this is set out at paragraph 82, subparagraph 4 in particular, at page 315. Now, the judge concluded that the regulatory regime was indifferent to the relative ranking of PLC's subordinated debt because it didn't matter from a regulatory perspective. The only thing that mattered was that all subordinated debt ranked lower than unsubordinated creditors in order to count as regulatory capital. So it's not clear why the regulatory regime would provide a favouring of pari passu. And as I said to your lordship earlier, I think this morning, that may well be why the FSA standard form doesn't deal with it, because the FSA doesn't have a concern. It would obviously be open to the parties to specify pari passu ranking, but they didn't resubmit. And all the statutory regime provides for is that the two debts entitled to prove at the same time rank for distribution pari passu. But that begs the question as to what the parties agree on subordination. So unless one disapplies the subordination provisions entirely, as the judge did, you don't get to pari passu. And therefore the suggestion that there is a purposive construction that leads you to pari passu we submit with respect is wrong, similarly an implied term. And then I think the final arguments relied upon by my own friend are that it's commercially implausible to suggest that the FSA standard form did not permit pari passu ranking of subordinated debt. That's at 81, subparagraph 3. But the answer to that is, well, you have to look at the express terms of this contract. And if there are inferences or commercial reasons why pari passu may have been the right reason, then my own friends argue that, but that's not what he's arguing, as far as we can see in these paragraphs. He also relies on some sort of alleged general market expectation, I think Mr. Beltrami addressed this, that all LT2 Tier 3 debt, subordinated debt would rank pari passu, and Mr. Beltrami's outlined why that's not sustainable, and it's not based on any finding made by the judge. We prefer court panel 161 of the judgment, which seems to be opposite to that. So, my lord, that's why we say that if you look at the alternative argument, you see that there isn't we would respectfully submit, purposive commercial construction, or a basis for an implied term. So what you're really left with is the conclusion that even though, it's a stark conclusion, even though the contracts are operative and functioning as contracts, the subdebts, the subnotes, the mere fact that the court can't find a solution to the interaction means that the subordination provisions are effectively completely set aside or abandoned. That's the judge's solution. The only alternative solutions are a textual construction, which means you never get into that, or looking along the Bromerin approach for what the parties would have intended in a scenario they obviously hadn't anticipated or foreseen in the express terms clearly enough, and then finding the solution through the contractual structure. And the solution I'm offering is one that is commercially grounded and has force from the terms that I've shown you. I've got one alternative case, which I'd just like to take very shortly, which is set out in writing at paragraph 62 to 66 of my skeleton. And this is our ground through A. This case proceeds.
Sorry, can I just ask you this? I know you're not involved in the rectification appeal, but the point has been made very forcefully by Mr. Beltrami. The question is not what the parties would have agreed, but what they did agree. And if you're in the what they would have agreed, had they thought about it territory, you can't rectify. You're saying, well, if you know what they would have agreed had they thought about it, you don't need to rectify, you just buy the contract. Is there a tension between those two positions?
I don't think so. On rectification, what's being said is that the parties actually intended something else, and that the court can see from the relevant evidence that's what was intended across the line, and so on and so forth. And therefore, the contract can be rewritten to reflect what was the party's actual intention. And for the purposes of rectification, where you strike a line through what it says and put something different in, which is the case of being advanced, that's the test. What I'm putting forward is different, which is you've got contractual provisions that it's not clear how they are intended to operate on their face, but either the court is then faced with simply striking them out and saying we're not going to give effect to this bargain because we don't know how to interpret it, or, which the court has done additionally, is to look at is there an objective inference of the party's intention to what they would have intended in order to make this contract work.
I just had this sort of uncomfortable feeling that rectification is supposed to reach the parts that contract can't reach.
It's the important difference that in rectification cases, the intention you're looking at is a subjective intention.
Exactly.
It has to be shared. I mean, that's the point that the Court of Appeal cleared up following endless disputes and disagreement about that topic. Whereas on your argument, it's objective the whole way.
Well, that may be the
That's
answer.
exactly right.
I mean, it's only quite a narrow area of ground where one approach differs from the other, but it does differ in our critical inquiry as to what was actually subjectively in the minds of the protagonists, which is completely irrelevant to the question of contractual construction, including the Bromerin extension.
Exactly. There's also one other difference just from the facts of this, which is Mr. Phillips is seeking to change the clear wording to mean something different, whereas I'm in a situation where, on a different point, everybody agrees on this hypothesis, but one has to work out what it means.
Yeah. Anyway, ground 3A.
So we've covered this in writing, and this is a point that proceeds in the alternative on the assumption that, contrary to our primary case, the judge was right to hold that claims C and D, the notes of the debt, could prove in PLC's insolvency at the same time. That proceeds on that hypothesis. And where we disagree on that hypothesis with the judge is that it doesn't follow, even if they can prove at the same time, that they would be able to be paid out in the same time. And why that is that there's a separate question of whether the contractual conditions to payment of each debt have been which requires a solvency test to be applied. So putting that a little bit more clearly than I've just done. The first stage of the analysis was to consider when in time the two debts could prove, and the judge says pari passu. That's not the end of the question, because the next stage then would be, this conceptually different stage, whether the conditions to payment of each of the sub-debt or the sub-notes have been fulfilled. And then that requires looking at the solvency test within each instrument. And if you look at that second stage in that way, claim C would qualify as a subordinated liability under the notes because it ranks pari passu. But claim D would not qualify as a subordinated liability because of the different definition. And so the contingency under the PLC subdebt would not be satisfied unless PLC could pay claim D in full, which it can't. But the contingency in the note would be satisfied without taking into account claim C. And so the upshot is that claim D would have to be valued at zero for purposes of distribution. Okay. Claim C would have to be, sorry, the debt. 'Completely different argument.
We better have a look and see what the judge said about permission.
So, first of all, Michael, I've shown you that the argument that the judge addressed was an argument as to whether the party actually agreed the remedy. And there was then a debate at a hearing. Can I just show you this? And I'm sorry to do this, but the order itself is, we just say, very confused. So I have to go through the transcript, which isn't ideal. But the transcript is in supplemental bundle 2, tab 58. And the relevant page of the bundle is 620.
$6.20.
620, so it starts at page 207 in turn number.
Yes.
And the debate had been over appealing in relation to the request for dividend stopper, but there was a mismatch because obviously the bank's argument is an objective argument that the judge found as to subject. And the judge was saying to my Lord Justice Fisher that the order would contain an effort at both the positive and negative side of things, apparently, line 11.
This is page 207.
That's
Yes.
right, top right hand corner.
Yeah.
And he says, whilst I do consider it for the Court of Appeal to decide what is a construction point and what isn't, it is for me to decide whether the dividend stopper, as I framed it in my judgment, goes forward and I'm making clear it does not. Now, there may well be means by which the material which at the moment is addressed under the heading dividend stopper can be regarded as a construction argument. That's a matter for the Court of Appeal. And he then, one drops down on page 208, line 4, says, I've taken the view that most of what we call dividend stopper argument isn't construction. If you want to say abilities, that's a matter which you can run as a matter of construction. It's for the court to say what is and what is not within the line of voting test. And then if one drops down again to line 19, all I'm saying is that the pure dividend stopper argument, as I characterise it in my judgment, is not by my permission going further. Now, what I understand from that is he's saying you can't can't appeal on my factual findings against this fact. There was no actual agreement, and that's the argument he addressed in the judgment. And there's no attempt to run that or appeal against that because it wasn't a case of the bank argument. But he is saying that insofar as you're saying it's an on or written objective construction point, then that is a matter that you can run as a matter of construction in the Court of Appeal. So what we would suggest to your Lordship is that's plainly what this argument is, and it's
and the order says.
The order says, if I can show you, it's call button 2, tab 23, page 4. So it's paragraph 17. So he gives permission to appeal the declaration, paragraph 7, which is the finding on the seniority ranking. And then he says it's as defined in paragraph 32.2 and further explained at 366. Any contention that the court erred in making factual findings or rejecting the arguments made or recorded as having been made and described in the judgment. So there's no attempt to appeal his factual findings or indeed the arguments made as recorded in his judgment. It's an entirely different argument. He didn't appeal it.
It does look like a fairly comprehensive, worded attempt to rule out any appeal on really anything to do with
I agree, and I was just about to say that the problem with this order is the word included.
Yeah.
And the reference to 32.2. So it is a very confusing order, and that's why I've had to show you the transcript, because the judge did say in terms that the construction point was open to us. And also, it's a rather rum order in circumstances where the judge didn't deal with the construction point that was argued. And so, well, I'd submit that having looked at the transcript and the order, which is quite frankly quite confused, it's clear we do have permission, and the reality is it's really for your Lordship now to assess the merits of the argument as it stands as a matter of construction.
I mean, wasn't the wording of paragraph 17 a matter for agreement between counsel? I mean, was it the judge? He didn't draft the order himself, did he?
I'm sorry, but I have some instructions. I wasn't involved.
Sorry, I've forgotten that, yes.
I
It was
accept.
settled by the judge.
It was settled by the judge, right?
There was a lot of back and forth. We didn't agree, and so the judge settled. I'm sorry, I didn't want to interrupt.
No,
you.
I'm grateful. So. I'm afraid that the order gives rise to a number of instructions itself.
What he's refusing permission for is the argument as defined in paragraph 32.2 of the judgment, and as further explained in 366. Well, as far as I can see, 366 does not explain the argument, but 32.2 does. And if you go to 32.2a, it's quoting from, I imagine it's one of your position papers, and this is all about, quotation from paragraph 30, is all about commercial rationale for the ranking advocated by Deutsche Bank. So it is being used there, it seems to me, as an aid to the interpretation, and the judge has refused you permission to run that argument, has he not?
But
And I don't think you applied to this court against that refusal.
my lord, I understand we didn't, but what the interpretation interpretation with the transcript that was given to this, it is that it was against the, as he put it, the pure dividend stopper, the words he used in the transcript, which is what he explains in 365 to 377.
Well, I understand that, but appeals are appeals against orders.
Well, my lord, all I can do in that situation, having argued this and seen the problems, is ask the commission now if there's any ambiguity.
Right.
Okay.
All right.
If there is a difference between what he said in argument and what he actually said in the order which he finally drew up himself, apparently, I suppose we're not ought to take the latter as his finally considered view on the matter.
Well, I understand that. I think there was some confusion about what the judge really intended. But as I say, the parties have both.
Yeah.
sat there.
Well,
Yeah.
we've heard your side of the argument.
We've heard it.
Whether we hear Mr. Phillips' side of it, we will decide.
I would just, if there's any ambiguity, I'd ask the commission now.
But Ms. Delaney, you'd also presumably rely, although maybe I've just read it too quickly, upon paragraph 32(2)(b) of the judgment, which says, because of the generality of the points, I'm going to deal with it later at H, which takes you back to the different argument.
It does. And that's why I said, if you read, I think if you read everything together, he's dealing with the argument he dealt with. But I fully accept on the face of the order, it appears to be.
Right.
My lord, just one point described in the public past, which is that, I think in answer to one of my Lord Justice Henderson's questions, LBHI accepts that the sub-notes were listed for tax purposes, and the reference to that is the reply position paper, paragraph 18 to subparagraph 1, and the reference is called on to tab 37, page 6.
Thank you.
My lord, I'm carrying on, because it's now
Fine.
on a different topic, which is partial release.
Yeah, this is the rule against double proof point, isn't it? Yeah.
My lord, the issue for the court on this topic is what is the effect of LBHI releasing this claim as guarantor in respect of the PLC's sub-debt in PLC's insolvency as part of a settlement agreement?
It's common ground, is it? That's what the settlement agreement did. This is clause 8.02, I think, which, speaking personally, I find very hard to understand. But it looks pretty comprehensive, whatever it does.
I can show you from my learned friend's skeleton the facts. which show
Yeah,
it's
well, it
comprehensive.
seems to be agreed that in its capacity as guarantor, LBHI has given up its right to be indemnified by the principal debtor.
That's exactly right. And this is actually therefore quite a short note.
Yeah.
Because the point is simply what's the effect of the release on a rule of insolvency.
And
So
that is not a feature, as far as I can see, of any of the cases to which we have been referred. It's not a feature of the Australian or the New Zealand cases. So we don't need to choose between them, do we?
No.
All we have to decide is, does it make a difference that the surety no longer has a right to be indemnified by the principal debtor?
Exactly. And it's common ground that in an insolvency where a surety has guaranteed payment of a debt, the creditor can prove the full debt, even if the surety has made part payment of the debt, and the surety can't prove. That's also common ground. It's common ground. That's a special rule in insolvency. And the rationale, as I'll come on to show your lordship, is to prevent competing claims in insolvency for the same debt. And the creditor is treated as senior to the surety and therefore has the right to prove for the full debt and will account to the surety in the event of a full recovery in that scenario. But as your lordship has just said, this case is a novel scenario, not considered by authority, because you've got the release, so there is no longer the competing
Yeah.
insolvency. And the question is then, what happens to the special rule? And we say that given that there is no competing claim, and that's the rationale for the rule, the special rule doesn't apply, and the creditor's proof should only be admitted for the amount that takes into account his own debt, so less what he's already been paid, because any other result would unjustly enrich the creditor and subvert the pari passu rule, because the creditor would be receiving at the expense of the general body of unsecured creditors an excessive distribution. And we say that's the only result that makes sense. Now, we also say that to the extent the lordships are interested, accepting that it's not definitive, that outside an insolvency, that would be the case, that the claim against the...
That's MS Fashions.
Exactly. So we say that that is the position, there's an argument about that. But actually, on my case, I don't even need to proceed on that, because if I persuade your lordship that the special rule has no application...
But I think you do, don't you? You have to say that that's the position outside insolvency, because if you can't say that's the position outside insolvency, then none of the creditor's debt has been repaid, so it's all outstanding. So he ought to be able to prove for all of it.
Well, my lord, it could say that, but what I was going to say was that, in a sense, you've got the special rule.
Yeah, but your point is the special rule doesn't apply where the surety has given up his right to indemnity.
What I'm saying is exactly that, and in an insolvency situation,
well,
you've
hang
got
on a
to
minute.
have the special rule.
Suppose that the surety, suppose there's a debt of £1 million, and the surety pays £500,000. And let us suppose that outside of an insolvency, that does not discharge the surety's debt, or the creditor's debt. And let us suppose that the surety has given up his right to indemnity. Creditor surely in those circumstances, because his debt has not been repaid, could prove for £1 million. And if a dividend of say 60p in the pound were declared, he would pocket 600,000 out of the insolvent estate, add it to the £500,000 he's received, total 1.1 million.
And get a windfall at the expense of the estate and the other creditors. So that's why we say that there are two stages to the analysis. I'm happy with taking both together, or actually I'd say I'd win on just the first stage, which is that because this is an insolvency situation, you've also got to have in mind the effect on other creditors if you allow a proof for too much. And that's why the special insolvency rule shouldn't apply here. But in any case, I say that that reflects what would happen outside the insolvency position, and I would therefore give the court some comfort that it was the right answer for that reason.
Yeah.
Now, I would, at the risk of saying something negative about the judge again, the judge just didn't deal with this point. The relevant part of this judgment is at paragraph 288 and 383. But what's just a bit startling about this is that the key point of the lordship is identified is what's the effect of the release. The judge never even engages with the question of the release, despite it being in a clause for closing date and proved out when the judgment came to trial. So Lord Justice Newey gave permission, and this court is essentially hearing the argument fresh. So, my lord, turning then to cases that arises, the facts, as your lordship's identified, common ground. They're set out, if your lordship needs to see them, at paragraph 88, my learned friends statute, so you can be confident of the commonality of that. And what's clear, therefore, is that the guarantor's claim for an indemnity, having made a part payment, has been released. And LBHI was the guarantor, its claim is as the assignee of the original holder, so its only claim is the principal debtor.
Yes, wearing a different hat.
My lord, the special rule applicable in the usual scenario is set out in Asplin argument of paragraphs 81 and 82.
Yes.
And the rationale is explained in some of the text. So if I could show you by way of example, authorities under tab 71.
Sorry, which authorities find that?
Four.
Bundle 4
Thank you, sorry.
at tab 71. And looking at the second page within the tab, which is 2363.
Yeah. This is Andrews and Mellis, I think.
It is. And what you can see, you read the first paragraph.
9001.
No, it's 13002, I think it's the second page.
Oh, sorry.
2363.
Yes.
And what you'll see is the essence of this rule is that the insolvent estate should not be compelled to entertain more than one proof in respect of the same debt, or to do so would unfairly distort the pari passu principle of distribution of insolvency. And then if your lordship goes down to the paragraph under the heading Ray Captain Singers, the third down, in the middle of that paragraph, you can see a sentence, PD has the primary obligation to C, etc. But if PD is insolvent, S may not enforce that right in competition with C.
Yes.
And then if one goes over to 2369 of the bundle, it's 13007. This is just in showing you the part payment point, and it's the same point if one looks about 7 lines down about receiving a dividend in competition. So
Yes.
if I could just emphasise 4 points. The first point is that it's an approach that's adopted as a special rule in insolvency proceedings. Second, the rationale given is important. It's because the surety has undertaken to be responsible for the full sum guaranteed that the surety is prevented from proving in competition and claiming its right of indemnity. And so this rule reflects the subordinate status of the surety. The third point is that the idea is also to prevent there being 2 proofs for the same debt, competition point. And the fourth point is that the estate bears liability for the full amount due. therefore the creditor proves the full amount. But we would suggest that that's predicated on there still being a competing right. It's just it's not being manifested in a separate proof.
Just say that last point again.
The fact that the creditor can prove for the full amount, we say, is because there is the premise that the surety has a right to be indemnified.
I see.
And the point is that's why the estate still owes the money. And the assumption would be that the creditor will account if it recovered the full amount, because that claim is there. And this rule is about not allowing a competitive or double proof.
And not requiring the estate to enter into an inquiry about these matters.
Exactly. You then come on to what's the impact of the release. And here, the creditor has benefited from a payment by the surety. The estate is not liable to make any indemnity payment to the surety. So there's no prospect of competition between the surety and the creditor.
I'm sorry, I'm going to have to ask you to say that last part again. The creditor benefits from the payment from the surety, and then he went on, the estate is not liable
To make an indemnity payment to the surety. And then thirdly, because of that, there is no prospect of competition between the surety and the creditor. And therefore there is no risk of a double proof. So the rule against double proof is irrelevant. And we say therefore if there's no competition, no risk of a double proof, that only leaves the creditor's proof and the question of the amount of that proof.
The rule against double proof, that's a matter of judge-made law, is it essentially? It's not something one finds set out in the
That's
rules.
right.
It's one of the rules of judge-made law that Lord Neuberger refers to in Waterfall 1, which he says is capable of development.
And here what we say is there's an obvious policy reason that underpins the special rule, but where there is no surety, there's no good reason to allow the creditor to claim more than the creditor is in fact owed when there is no surety. And in answer to my Lord Justice Lewison's point, there may be an extra point in an insolvency which goes beyond the surety side, which is that otherwise the estate and the other creditors in an insolvency will be prejudiced by a creditor who's already had recovery gaining more than he should do. And we say that would actually be contrary to the pari passu principle of fair distribution. Can I deal then with 2 points that LBHI make? But first of all, it's suggested that the rule in Ray's SAS, which I'll show you, continues to apply notwithstanding the release, and that the bank's approach is contrary to that decision. And the short answer to that is that Ray's SAS doesn't deal with the scenario in which there's a release of the surety's indemnity claim. So we don't accept it's contrary to that decision. There's a sentence in it we don't agree with, and I'll show it to you.
Well, that's your overarching point, really, is that none of the cases that have considered this question have ever considered the case where the surety has released the right to indemnity.
If one looks at the underlying rationale, you say there's only one sensible answer, which is the only way you can avoid the risk of effectively the creditors as a whole getting too much is by limiting the original creditor's recovery to what's left after the part payment.
Exactly. That's why I said mine was a short point.
Exactly. Yeah, well, I think we've got that point.
Yes.
Can I ask another question?
Yes.
Andrews and Millett suggests 13008 that if you make a part payment under a negotiable instrument, the rule against double proof doesn't apply. Everybody seems to have taken the view that these notes are a negotiable instrument. Does that exception apply, or is that irrelevant?
My lord, I think that's irrelevant.
Irrelevant, right.
My lord, I'll show you shall I raise that, even though it doesn't deal with it unless...
By all means.
It's in volume 1 of the authority.
Yeah.
And it's in tab 1. The facts are clear from the head note, which is that an all monies guarantee was given to a bank for sums that became due or owing from a customer up to a limit of £300. Customer became bankrupt. The bank received £300 of the guarantee and sought to prove for the full amount without giving credit, and the trustee challenged it, and the court held the bank could prove the full guarantee sum. The big issue in the case was whether this was a guarantee for the whole amount but up to a limit, or should be construed as a guarantee only for £300, which would make a difference. So that was the actual issue of the case. If one looks at the judgment of Justice Williams at page 11 of the bundle, the sentence we disagree with, which I'm going to come on to develop, it is the second sentence, I think, of the common law right of the bank. So that's not material to his decision in this
Where does he
case.
get that from? He doesn't cite any authority for it. I've looked at the authorities that were cited to him. None of them seem to support that proposition.
And we say that actually the cases I've shown it's not right. But that's the sentence we don't agree with. But then if one carries on reading through the judgment, it's the third sentence that's actually key. When the bankruptcy supervened the rights of the principal creditor, and your lordship will see that the judgment in fact deals mainly with the question of this construction of the guarantee in this case. And he reaches the conclusion where, again, opposite the second hole punch on the page, it's true that his liability was to be limited, but he construes it as a guarantee nevertheless for the whole amount. And then he reaches his conclusion about the bargain at the end. So
I'm a little bit puzzled by the statement that if the surety is surety for part of the debt, then the principal creditor can only prove for the remainder, compared with his previous statement that at common law, the creditor can sue for the whole debt, never mind what he's been paid. I don't quite at the moment see how those two statements fit together.
that's right. But what his rationale, your lordship sees inconsistency. But for present purposes, there's nothing in that case that is contrary to the bank's position.
No.
Other than the outside insolvency point.
Yeah.
So, insofar as that's taken by LBHI, that's the answer. unjust enrichment of the insolvent estate and the general body of creditors, because the estate essentially gets a windfall that it doesn't have to pay off the surety. That seems to be his point. And what my own friend says at, I think, paragraph 105 of his skeleton. It's 105 subparagraph 2. That is in,
Sorry, I'm the wrong volume.
it's volume 1, tab 19.
Page 10, paragraph 102.
It's paragraph 105, subparagraph
105.
2. So he says it would be a windfall. But then if one then goes back to 87 subparagraph 4, page 317. What you can see is this continues on looking at Ray Sass. But you see on the fourth line, if LBHI cannot prove it as surety at all and cannot prove as creditor for the full amount, that would result in unjust enrichment. But obviously, LBI cannot prove as surety because it's released its right to do so. So if the premise is suggesting that LBHI can't prove, then it just ignores the release. And if the release has given a benefit to the estate, presumably it's been done for reasons that are known to LBHI, but it shouldn't be allowed to permit the principal creditor to recover excessively at the expense of other general body of creditors. I think that then deals with the position as a matter of insolvency context. I'm not sure there are any more ways I can put the same point. That takes me on to then the position outside of insolvency. And as I said, I recognise the point's not determinative, but we say it is actually consistent with the analysis. And we've addressed this point at paragraphs 72 to 80 of our skeleton argument in bundle 1, tab 18. And if I could just start with MS Fashion and PCCI, which is in Authorities Bundle 1 at tab 16. Very familiar decision. The decision is obviously focused on the question of settles, but the facts are relevant, and there's a general statement of principle on which we rely. And if I could show you the general statement of principle first, and then I can show you the rest of the case. So, if you go to page 448, letter D.
Yeah.
You see, if there is a set-off between Mr. Amir and Mr. Ahmed, who are directors giving guarantees, that must automatically reduce or extinguish the indebtedness to these other companies. And then if you drop down, it operates to reduce or extinguish the liability of the guarantor and necessarily therefore operates as in effect a payment to him to be set against the already received from the guarantor. That general statement
Yeah.
principle.
I found to say, I mean, the natural, I suspect, the off-the-cuff reaction that most lawyers to that is say, well, of course that's right.
Exactly.
And it's only when you look at re-SAS, you begin to think, well, actually, is there a different rule after all?
Exactly. And I think that the points that are taken by my learned friends are, they suggest that the payment from the directors was being analysed as a principal debtor payment. And that's not right. They were principal debtors and guarantors. And you can see that the relevance of the principal debtor status was that the court held there was no need for a demand before payment. So that was the relevance of it. And one can see that if you start with the judgment of Lord Justice Dillon at page 291. 291 of the bundle, I should say. And you can see the broad proposition stated at 444 at the top, which sets out what the issue is. And then at 447G to H, you can see that the court considers at the bottom that the effect of him having liability also as a principal debtor was to dispense with any need for a demand.
Yeah.
The other point made by my own friend is that the case is somehow limited because it's dealing with settle. And we would suggest that the passage that I've shown your lordship at page 448 D to E is not so limited. It's a statement of principle, as my Lord Justice Henderson said, seems a very obvious one. So we don't see a reason for suggesting that that principle is limited to settle. And nor is it limited to a case where there's a charge, which is another point I think that was taken. But we then come on to the authority at tab 19.
Can I just make a couple of points about MS Fashions, which I think may help you? You'll obviously know that the case came for Lord Justice Hoffman at first instance. If you look at page 427 of the report, you'll see that Ulster Bank and Lamb was cited to,
That's right.
which is one of the cases we've been referred to. If you go on to 432, letter B, you see that Mr. Justice Millett refused relief, but the Court of Appeal allowed an appeal. And if you look at the report of that appeal, Lord Justice Scott says exactly the same thing about the effect of payment by a guarantor. I think he uses the word clearly. And then if you look at the declaration that Lord Justice Hoffman made, page 439, the order itself is not set out in the report, but he says he's going to declare the indebtedness of each of the companies, that is, companies to BCCI, has been extinguished or reduced by the amount standing to the credit of the directors. And that declaration was upheld by this court. So that's the ratio.
Exactly. You're absolutely right. And it's clear that it's not limited to settle. My lord, if we then go to the authority at tab 19.
This is Milverton.
The case involved a lease under which there were 6 people liable to pay the rent by reason of being the tenant, former tenant, or guarantors of the tenant or former tenant. And a claim was made against the original tenant for the amount of rent. And it was disputed on the basis that some of the guarantors had made part payments which no credit was given. And the landlord said that no payment by a guarantor could extinguish the liability of the tenant to pay rent, and that these payments have been made in return for a lease under the guarantee. So that this case involved an argument in particular that the payments have been made in return for a release under the guarantee. I should just say as a point of distinction, there's no suggestion in this case that the indemnity was in any way by virtue of the part payment release. The first paragraph of the report, decision of Justice Glidewell, identifies the issue of principle, and it's framed as being as to the impact of receiving payment from a guarantor in return for a release of the obligations as a guarantor. And as I said, there is a point of distinction here because that's not the position. One then goes to page 5, and halfway down the page, Lord Justice Glidewell identifies the first question considered by the judge. Does payment by surety an instalment of a lessee's rent discharge the lessee's obligation not to pay the same rent? And the question is posed by reference to the surety making payment, and the passage quoted from Woodfall is to the same effect. And Lord Justice Glidewell says over the page on page 6 that he doesn't think the authorities cited in Woodfall support the proposition. And if your lordship could read from halfway down, I agree with the judge's conclusion on this issue at the end of the paragraph.
Yes.
So the court is saying that the payment by a surety does operate to pay the rent for the relevant period, and this is approached on the basis that the payment is made as a surety. See that from the reference to lessee and assignee and a surety. I make that point because Mr. Phillips suggests that this case should be read as if it's 6 principal debtors, and that's not right, as you can see from the passage. And if one drops to the second hole punch, you can see the explanation as to why, and the point that it would be so unjust that equity would prevent it in the middle of that paragraph, starting with the sureties have each made a payment.
Yeah.
And on page 9, you then have the decision of Lord Justice Hoffman was then agreeing, and the key passage is at page 9, the red-lined passage, where it was argued that the payments were made in consideration for being released and not in satisfaction of the guarantor's obligations. And if your lordship would just read for the purpose of deciding, which is in the middle of the highlighted passage.
Yeah.
And we say that that makes it plain that the payment wasn't to be treated solely as in return for the release, but was referable to the guarantee. And in this case, anyway, there's no release of the guarantee.
Neither Andrews and Millett nor Sir Roy Good much likely that decision.
No,
Chitty, on the other hand, seems to think it's right.
that's right. There's a lot of academic disagreement on this, and in particular the policy considerations. But we suggest it's obvious that if you've got the money, you shouldn't have to get it twice. And the special rule in insolvency is about competitive prudence, not about allowing double recovery.
And even in insolvency, it does produce a rather clumsy outcome, doesn't it? I mean, if you have to pay the full amount, even though, so to speak, you've already received credit for half of it, you end up with a rather complex and unsatisfactory solution of the surplus being held on trust for the surety.
That's right.
Now, and that can give rise to all sorts of problems of enforcement and ignorance of rights and goodness knows what. It seems to make far more sense to say you should just reduce the debt pro tanto rather than have all this superstructure of opportunity for things to go wrong.
That's absolutely right. And even more so here, where you've had the surety make a deal, why should the court then try and in a sense, go behind it to give the surety more.
Well, I mean, yes, it's a fortiori case.
It is. My lord, the only other case I was going to show you, but I don't know whether, having seen those who wish to see it, is the Octavar case, which is in bundle 2 at tab 34, an Australian decision. And the relevance of that case really was to say that Ulster Bank and Lamb was wrong, and that it shouldn't be followed, and really to deal with some of the criticisms made in Good and Text about favouring the position of Ray Sachs. I can show you the decision, obviously it's not a decision of this court, but it's informative.
Well, it's up to you, Ms. Delaney, but if, at the moment, I think, MS Fashion's ratio is that the liability to the creditor is partially discharged, and if I'm right to say that that is ratio, then it binds us, so it doesn't really matter what the Australians think.
Well, I will leave it there, but with liberty to respond on this case.
But I mean, if you want to, this is Murdo J, is it? Yeah. Well, he considers Mr. Justice Fisher and Mr. Justice Tadden and all that, and he goes through it all.
He does. Yeah. And he thinks clearly that it operates in the way that MS Fashion suggests, and that previous authority doesn't exist.
Well, speaking for myself, I have read it.
Well, I don't think, my lord, I've then got anything to add. We have one further alternative point, which is thinking of answer to Mr. Phillips, which is Mr. Fisher is going to deal with it first, unless I can assist you further.
Right?
My lords, my ladies, it's a very brief point just to add to those made by Ms. Delaney. And we made it in our skeleton argument at paragraphs 98 to 101, which is at tab 18 of the first bundle, page 285. It's tab 18, page 285, it's paragraphs 98.
Yeah. Relevance of clause 7F.
That's correct. And my lord, it's a sum, albeit perhaps not too much relevance, but we rely on it to make this point, which is one of the arguments made by my learned friend, is to say, well, as Mr. Lane pointed out, any other result is unfair to them as the creditor. And we say it works the other way around. We say, unless we're correct, the unfairness is suffered by the estate because there's a subversion of pari passu. But the one additional point we just wanted to draw to your attention was the way in which the documents have anticipated this scenario would actually work. And that's where clause 7F comes in at the subset. And if I could just ask you to take that up, it's in core bundle 3, tab 43. Page 759. And these are the standard terms and conditions which form part of all of the subject. And one can see at page 759, 7F, there was an undertaking from the lender that they would not take or enforce any security guarantee or indemnity from any person for all or part of subordinated liabilities. And the lender shall, upon obtaining or enforcing any security, guarantee or indemnity, notwithstanding this undertaking, hold the same and any proceeds thereof on trust for the borrower, instead of PLC. Now, as far as we are aware, that did not happen. And there has been no suggestion that any monies were retained on trust for PLC. And this issue proceeded before the judge in accordance with the agreed facts effectively shown by Ms. Delaney. But the point we make is very brief and is based on the economic effect which would have occurred had clause 7F been complied with. Because in that scenario, my lords, my lady, the monies received would have been held on trust, PLC, and PLC would have been entitled to them in the case of insolvency. And so although they wouldn't have been applied in satisfaction of the guaranteed liability, there would have been no set-off, and effectively the economic result would be the same as we're now advocating, because the monies would have had to go to PLC in full, because they were held on trust, and although the creditor would have therefore retained a claim for the full amount, you'd have had to hand over the monies which had been held on trust, and the net effect would have been, as we now advocate, that they would have been limited to economically a claim for effectively the difference between full guaranteed sum and the amount being paid by the guarantor. Now, we say that's just a further point to note, and in support of the arguments made by Mr. Laney, that there is in fact no windfall to the estate in the scenario which we're positing. And the way in which the rule should operate is exactly as we have said, which avoids unjust enrichment of the creditor at the expense of the body of creditors. Now, an objection is taken to us relying on clause 7F by Mr. Phillips. We did raise this in our position paper. It wasn't argued at trial before the judge. All I'm relying on it for is to make this observation in terms of economic effect. If one looks at the terms of the document, it's quite clear what should have happened. And there is a parity of outcome between what the document anticipated and the result for which we're arguing as a consequence of the partial ruling. My Lord, my Leader, that's the simple point we have in clause 7.
Right. Well, you can have 5 minutes now if you want, Mr. Phillips, or if you like, we can start fresh tomorrow.
My Lords, I am feeling like the 12th man for sure in this case. It seems to be my place to finish the day and start the next day. My Lords,
Night Watcher, I think they're called now.
Night Watcher. With my eyesight, I'm not sure I'd call me a watchman friend. My Lords, may I just trouble you on one point?
Yes, of course.
Which will assist us hugely overnight, depending on the answer to this point. And that is the question of the dividend stopper. If, my Lords, you take the view that I do not need to address you on the dividend stopper, that will save
Yeah,
you.
all right. Well, I'll tell you what, we will go out. We'll
I'm sorry.
See where we are. It doesn't matter. Don't go away. We will come back and tell you within the next 5 to 10 minutes.
I'm so sorry. My learned juniors just made a point that when you look at 32.2, where at 32.2b, where the learned judge says because of the generality of the point, and he goes on to regulate the generality of the point was sorry. It was the generality of the point was it was common to LBHI2 and PLC. That's what that meant in that paragraph of the judgment. I'm sorry about that.
Don't worry. Well, we will go out and we'll be back in 5 to 10 minutes.
Thank you very much.
Leaders in this case have to that thing. Huh? Leaders that wait, may not be here.
I think I should sell tickets for me again. That's going to be a humbug.
I was only thinking today or yesterday.
Yes.
No, I just want to
Yeah.
Yeah.
I mean, it's a very weird offshoot. Yeah.
There's a lot to do.
Things are against the reasonable man wouldn't think that you could address it. It is weird. See, Lewis is thinking, what? I need to look at my book again. Please.
Well, I think he's with us. You're on. The thing is, so that everything else is. Guys,
And also, yeah.
guys, on partial release, maybe I haven't done it. Very forensic data loss. Because if I take them on, sort of
Well, the thing is,
anything other than
so when you live in it,
Should we have a correspondence?
so we,
No, shall I?
how much money?
at this rate, the less something goes wrong. But I mean, perhaps you
Well, if you do want to do
you heard them.
well, let's talk about
This doesn't really
You've been in this
go
case
forward. This doesn't really go forward.
it's the whole night.
Yeah. Wilson. I take it.
Well, we have some sympathy with Ms. Delaney's position looking at the transcript of the consequentials hearing, but we are all of the view that the order is clear and the argument is not open to Deutsche Bank.
Thank you very much, my lords. Your lordships understand why I asked, and I'm
Of
very
course.
grateful.
All right, 10:30 tomorrow.
You only said that at the beginning.